co-team member, Ms. Akansha Kumari, to please start with a brief introduction of Professor Dr. Andrew Goodman.
Thank you, Dee. Well, good afternoon to one and all present here. This is Akansha Kumari and Geo Goodman, sir, barrister and bencher of Inner Temple, Royal Institution of Chartered Surveyors and ABA Rule of Law Program, convener SCN UK. Sir is a barrister since 1987 and an accredited CEDR mediator since 1993, practicing in commercial, construction, partnership, franchising, professional negligence, higher education, and farming disputes. He has been recommended as a leading junior in professional indemnity claims and as a leading mediator in the Legal 500 for 25 years and for 4 years by Chambers Directory as a leading practitioner in ADR. Sir is currently a member of the BARS ADR panel, the Independent Standards Commission of the International Mediation Institute, and co-vice chair of its Mediation Advocacy Appraisal Committee. He is acknowledged as one of the world's leading specialists in dispute resolution courses at UCL and a peripatetic lecturer at 7 other UK universities. He has provided at the ICC Paris, the author of 50 books on mediation advocacy, how judges decide cases, and effective written advocacy in practice. So it is a privilege to have you. Now, I would request Sir to please kindly address the gathering. Thank you.
Thank you very much. I hope everybody can hear me and there aren't too many technical difficulties. Welcome to a very cold and miserable morning in London. And it's my great pleasure to be in a position to speak to you this afternoon after your relatively short lunch break. I should also indicate that my friend and colleague, Andrew Miller QC, who is currently working in Dubai, tells me that he has he's having difficulty with the traffic in getting back to his hotel. So until he pops up, I may trespass on what he was going to tell you about and hold the fort for him. I've been asked to talk to you about the role of the negotiator in mediation, and I want to extend that in a particular way, and I'll explain why. In 2017, I was privileged to coach a student mediation team from a small college in Panjim in Goa called Salgaocar College. And we managed to reach the final of the ICC competition in Paris. I can assure you it was far more to do with those very able students than it was to do with me. But to my utter astonishment, we progressed through the rounds. And I have to say, in fairness, that I never thought for a moment that we were going to reach the final. And that being the case, I'd already booked a trip on the Eurostar back from Paris to London, and I had to leave the team to get on with it. And two things happened to that team during the final, which I hadn't planned for. The first was that I hadn't told them that the final would itself be in a very large hall, and much larger than any of the previous rounds. and they got very nervous, which was unfortunate. The other thing that I hadn't planned for and hadn't anticipated as a coach in the competition was what happened to them during the course of the final. They found themselves, what's a good word for it? I would say they found themselves bullied by a very aggressive negotiating team in the final. And they found themselves very disconcerted and uncomfortable. Now, one of the things that you can imagine a coach never tells you in the course of competition work is to say, we're not standing for this, we're going to leave. And in real life, negotiators who felt very uncomfortable because they were being treated unfairly or bullied, not being protected by the mediator, would simply say, this is not acceptable, we are going. And if I had told them to do that, I think as a judge, I would have awarded them the competition, because I would have thought that the reality of the situation is that's what would have happened in real life. But of course, in mediation competition as students, you wouldn't dream of standing up and saying you were going to leave and then walk out. It's what I would call a high-risk strategy. But the fact of the matter is, it got me thinking about the difference between what we do in competition and what we do in real life. And I thought it would be worth spending a little bit of time just looking at the differences, then obviously focusing on the role of the negotiators during the course of mediation competition. Because as judges, we're looking for reality. We're looking for a commercially realistic outcome in respect of the negotiated mediation session. And we're looking for the party representative, be it lawyer or mediation advocate, and the party to work as a team in a very realistic way. And it seems to me, therefore, that we should dwell just for a few minutes on the distinctions between what the role of the negotiator is in real life and how we concertina that in competition for the benefit of the kind of work that you are planning to do. So in reality, of course, the very first thing that happens is that the person who becomes the negotiator, usually the lawyer, has to persuade the client to mediate in the first place. And there is a reluctance because it is still not generally within the public consciousness of what mediation is, and it will take a long time. People understand that if they have a dispute, they go to court, but very few, it seems to me, still understand the option of mediation, even though culturally, the way in which people resolve their disputes has been much more inclined towards mediation for thousands of years. So in the matter of reality, the negotiator or the lawyer, the party representative, is first going to persuade the client to mediate and hopefully persuade the other side to mediate. Then an extremely important function is to select the mediator, because in real life, a mediator isn't generally thrust upon you. You at the very least have a choice of who you want to be your neutral third party. And next you would agree the process, because if you were experienced in dealing with mediation, particularly commercial mediation, you would want to be extremely careful about the nature of the mediation process itself. And you have to understand that irrespective of the model that you will be using in competition, there are a variety of models across the world, including the fundamental distinction between models where the parties remain in caucus for most of the mediation, and a model where the parties remain together for most of the mediation. And you can imagine that therefore there is room in between those two extreme positions for the mediator and the parties to work out what they want to do. And then of course, that gives rise to questions of ownership. Who owns the mediation? Do the parties own it, or does the mediator own it, so far as process is concerned? So these are interesting questions which crop up in real life. And once you agree process, then the next job of the party representative or negotiator is to settle the mediation agreement. So most mediators will have a standard form agreement for the parties to sign, but the party representative has got to have a look at this and be sure that that's something that the party will agree to. And we get therefore this long line of functions of the negotiator or party representative, which occur in reality, but which of course do not occur in competition, because this is all taken care of for you before you start. You are taken to have entered into the competition on the basis of the mediation agreement, which has been provided. You don't have any say in varying the process. You don't have to persuade the other side to mediate because they're there already, and you don't have to select the mediator because that's part of the competition format. So we get on to the principal roles of the negotiator within the competition, and you can see how they track what happens in reality. So what is fundamental, of course, is that the negotiator is going to be in control of strategy. But we should never lose sight of the reality of our position. The process in which we are engaged is voluntary, and it remains voluntary. You can take a horse to water, so it is said, but you cannot make it drink. You cannot force the parties to enter into a settlement which one of them does not want to enter into. And therefore we need to have an understanding of the broad basis upon which the negotiator works. And it starts before you arrive at the venue. It starts before you turn up at the competition, because I suggest that preparation is everything. I often have difficulty when I'm sitting as a mediator. I often have difficulty with the lawyers who are representing the parties, because lawyers have a great deal of difficulty in showing their clients how they are earning their money when it comes to mediation. And in a trial, the lawyer knows exactly what's to do, well, what he's got to do, and he follows a very specific format, and the client can see perfectly well how he's earning his fee. But in mediation, it's much more subtle, and therefore this idea that there will be a lawyer who grandstands in front of the mediator and makes a forceful argument, that's not really what the judges are looking for in competition. They're looking for something which is more subtle, which is more adroit, but which is commercially realistic. So in the real world, as part of the strategy, we would be deciding who is going to attend, what their roles are going to be, what they will speak to, and what the outcomes are that they are trying to achieve. In competition, we already know that you, as one of the negotiators, will be acting in concert with your client as a team. And teamwork in competition is extremely important, because we're looking for balance. We're looking for an inclusive approach to the way in which the client and the negotiator, the lawyer, work together. And it's this teamwork which is it can generate a lot of points in the marking scheme. And therefore, it's something that you should always have regard to. And therefore, when you're planning the negotiation part of the exercise, you have to work out the level or the balance of whose voice is going to be heard in respect of which area. And in my experience, students tend to sort of formally divide up who is going to say what. But I think that if you look at the way things happen in real life, what tends to happen is that the lawyer would naturally take the lead, and then the mediator would draw in the client when the client needed to provide information which the lawyer himself or herself did not have. And of course, in fact, if the lawyer was occupying too much airtime, the mediator would probably intervene specifically to draw in the client. But in the terms of competition, there will be this balance, and the balance will be worked out before you come into the competition room. So what else are you going to be deciding before you arrive? Well, the whole structure of negotiation is open to you, but I want to lay stress on the fact that most of the decisions that you should be making should be made before you arrive. So the most obvious of these is to understand how and when you're going to make use of the mediator, how you're going to identify interests between the parties that could be reconciled, deciding whether you can make use of any imbalance of power which is in your favor, trying to generate options, specifically what you might be able to agree, which a court cannot impose, something different from what a court outcome would be. And how to demonstrate that you have all these facets and skills sort of rolled together as a package. Because ultimately, that's pretty much what the judges would look for in most competitions. They're looking for a package from which they can draw out these various elements. So I want to spend a few minutes speaking to these in turn. And I do apologize for not having any slides for you. First of all, you need to prepare in advance the opening statement, and you need to have a clear understanding of the ATNAs, the BATNA, WATNA, PATNA, and I'm making an assumption that you know what I'm talking about. So the opening statement is going to follow your mediation plan. It shouldn't really diverge from that at all. And I think opening statements should not be too lengthy. I think for competition purposes, I think the thing I would suggest is that you write them out and then learn as much of them as possible and practice in front of a mirror, because that will tell you how you look, and make sure that your discourse flows. Make sure there's no logical flaws in what you're saying, and then decide how much of your opening is going to be based on the strength of your legal position, and how much of it is going to move towards what I call the gateway to settlement, the areas that you are going to invite either the mediator or the other side to look at, which may create a momentum towards generating the kind of options that might be available for both sides to come together. I think in the opening statement, it's important to recognize that your client's position is firm enough to suggest that although you're coming to do a deal, you're not going to be doing any deal, but that you recognize that the deal to be done has got to suit both sides. And therefore, to that extent, you're happy to negotiate and you're happy to try and achieve something that suits both parties. And I would have thought the opening statement need not do more than that. Again, there's a balance on a firm, business-like approach to your own case, but the concession is you're there genuinely to listen. You've come with an open mind. You're looking for a settlement which is acceptable to both sides, and that you're prepared to work towards it. So there we have the nature of the opening statement. Now, I suggest that as part of your preparation, you should already work out some of the questions that you want to pose to the other side. And in particular, you need to be in a position to know what you're trying to achieve in each part of the mediation process. So for each part of the meeting or in the caucus, what is it that you're trying to achieve? Identify this before you start. And the reason I say this is because you're working on a time-sensitive basis. And because of time sensitivity, you don't want to waste the time that you have available. In terms of strategy, you should know in advance when it is that you want to have your private meeting with the mediator. And for competition purposes, what you're trying to do, of course, for the judges is to demonstrate how it is that you're going to use the mediator. It doesn't mean that the caucus is simply there to enable you to have this general outpouring of your confidential information. In fact, in real life, you wouldn't be telling the mediator your confidential information. You might be allowing the mediator to tease it out of you, but you wouldn't simply tell him all your secrets. At the very least, you have to trust the mediator before you're prepared that he or she should become the keeper of your secrets. But secondly, there needs to be a purpose behind providing confidential information, because what you're really doing is you are recruiting the mediator to your cause. The fact that he's working for settlement for the other side, that's fine. It's neither here nor there. As long as the mediator is working for a settlement for you, that's the basis upon which you should engage and recruit the mediator, particularly to get the mediator to find out things that you cannot simply by asking the other side. Now, if you trust the mediator, it's enough that the mediator has those answers. The fact that because of confidentiality, he or she might not be able to tell you is neither here nor there. I wouldn't worry about that. But once you've recruited the mediator to your cause using the caucus session to do so, the idea is that the mediator, even though the mediator is supposed to be neutral, the reality is you make the mediator a semi-detached part of your team in order to carry things to the other side that perhaps they won't hear directly from you because of the barrier, which is reactive devaluation. So prepare in advance to understand what it is that you're going to be doing in each part of the mediation. In particular, what you need to do in private with the mediator that you cannot do in open session. Understand your BATNA and construct it before you arrive. So work out where the BATNA is coming from. Is it coming from you, the lawyer, who understands whether you're going to win the case or not if you can't get a negotiated agreement? How much of it comes from the client? Because only the client has information which is either sufficiently technical or sufficiently commercial to be able to deal with an outcome which works. Because it has to be a workable outcome as well as a commercial solution. And try and identify the interests that your client shares with the other side. Because in every mediation, parties share interests. Generically, parties share the need to have the problem resolved. Parties share the need to have it resolved in an acceptable way for both sides. Parties share the need to prevent legal costs from continuing. People share the need to save tax. People share the need to have a workable solution. You understand that even generically, irrespective of the nature of the problem, you can identify interests which can be reconciled. And that is where the settlement is going to emerge from, the reconciliation of interests. And so you shouldn't be shy of asking the other side what's important to them. Why? Because you need to be able to gauge whether that can sit within a framework of material which is important to you, where they may make concessions as well. Well, what you're looking at is a sort of a bargaining framework. We will take this if you take that. And then in terms of prioritizing or categorizing things, make a long list, as long a list as possible, of things that your client might like or might want or might need. And having categorized them, prioritize them, and then get the other side to do the same. Get the mediator to get the other side to do the same, so that you can bargain together in this kind of a framework and create and generate the option for settlement. Now, because this is an international competition, you'll notice that most of the problems which have been generated have either a fictitious or a neutral jurisdiction. On that basis, you don't and you probably cannot anchor your arguments to any particular law except something which is a generic principle. So focus more on the facts than the law. And I would move away from the law unless it's readily identifiable and you can't do anything with it. You can't work with it. I mentioned the question of power imbalance. It's perfectly true that I would say the majority of disputes are resolved by reference to power, who is the more powerful party. In competition, we don't really like as judges to see the exercise of power. We like to see the exercise of reasoned argument. And for that reason, it's enough to indicate that you have power, but it's much better that you shouldn't have to use it. And I think, again, that's a matter where you would score highly with the judges. And of course, power should never be used as a threat in mediation, because, again, stepping away from the competition and looking at real life, in my experience, the exercise of power or the attempted exercise of power is more likely to drive the other party out of the process. So we've talked about teamwork, making sure that you divide up carefully who is going to say what. Don't use teamwork artificially. And when I say that, I mean, make sure that the contributions of the parties are realistic. You wouldn't get the client speaking to certain issues, and you wouldn't get the lawyer to speaking to certain issues. So when you create this balance, please make sure that it's realistic. Identifying things that the mediation process can achieve, which a court cannot give you. This part of option generation, I think, is extremely important. Most of the commercial situations which result in the kind of problems drafted for your analysis would suggest that there is a big difference between fighting a case in court and having the opportunity to negotiate a settlement outside court. So in competition, the judges are looking at genuine flexibility. They're looking at an approach which is different from what the court is trying to do. That's necessarily the case because a court is simply trying to decide who is right. And mediation does not decide who is right. Mediation is not interested in who is right. Mediation is interested in making both parties better off, in securing for both parties an advantage that they would not have had before they sat down at the table. And of course, mediation is designed to ensure that the mediator adds value. So one of the things you need to ask yourself as a negotiator is, how am I going to get this mediator in this problem to add value? To demonstrate to the judges that I know how to use the mediator in such a way that the mediator can do something for me that I cannot do myself. Because otherwise this would not be a competition within the context of mediation. It would simply be a framework for negotiating between two parties in the absence of a third party neutral. Make reference to the fact that the mediator is trained. The mediator understands how to act as a third party neutral and how to carry messages between the parties or hold parties' secrets in such a way that an atmosphere is created that moves inexorably towards settlement rather than maintains the barriers of hostility which exist between the parties before they arrive. Part of me thinks that in competition, the teams are often too nice to each other, too polite, unrealistically polite, if I can put it that way. And therefore, when I'm coaching my own teams, I always say, yes, polite is fine. Business-like is what we're looking for, really. But you don't have to go overboard in being nice to the other side in circumstances where, in real life, your lawyer would be quite aggressive. But on the other hand, there has to be a clear demonstration that what you are embarked on is a collaborative process. And it takes some degree of change of mindset to move from a process which is essentially competitive, that is determining the winning outcome in a binary process in court, to a process which is essentially collaborative, where you have to work together in order to secure the option that is best for both sides. Now, I have a mantra when I'm negotiating and when I'm preparing for negotiate, and that I use for my teams when we are engaged in competition ourselves. And it's really two parts of a single question. And it really focuses the mind when you're preparing. And I give this as a sort of free tip to everybody. And the question is simply this. I ask myself, how can I assist? How can I help the other side to get what they need? How can I help the other side get what they need, while at the same time getting what my client needs? And if you prepare in that way, it forces you to consider the needs of the other side. And that's a very valuable exercise, forcing you to consider the needs of the other side, forcing you to address the needs of the other side, forcing you to ask the other side, how can we help you? And if you think about it, how can we help you is a rather unusual way to start a negotiation, because most people presuppose you're there to get what you want. And it's difficult to make people understand that you are genuinely there to try and ensure that they get something that they want on the basis that you get something that you want. So I don't know whether that's of assistance or of help to you, but I think when preparing, it enables you to focus on the issues in a particular way. And I don't think it is any difference from a real life approach in commercial negotiation, trying to understand what we want by looking at what they want and seeing what value there is, what the relative values are in making a necessary concession. Nobody is suggesting that either in the competition or in real life that you simply roll over, fold your position, and give the other side whatever they want. That's not going to impress the judges, and it's not going to impress your own client in real life. But there is a way of striking a balance, and you need to have an understanding of how far you can go before you arrive. That's what the BATNA is for. So you focus on your BATNA or your WATNA, and that is going to give you a measure of the distance between where you are likely to want to be and where you can afford to be at the end of the negotiation. So I hope that's been of help or interest in looking at the role of the negotiators, both inside and outside competition. I want to spend a little bit of time covering for my friend and colleague, Andrew Miller. And I don't know whether he's arrived. Let me just have a quick
It's not
look at them.
joined.
No. So I wonder whether you would like to introduce Andrew Miller, and I will pretend to be him until such time as he arrives. And I'm afraid I'm not Queen's Counsel, but I still have ambitions.
So we'll do that. We can have a short introduction of Andrew Miller, sir. Preet, can you please take over?
Good afternoon, everyone. I am Preet Kaur, and I feel immense pleasure to welcome Mr. Andrew Miller QC and giving his short introduction. Sir has the experience of incredible 30 years of practice as a top-ranked commercial construction and insurance junior barrister and QC. Sir practices as a mediator and arbitrator using his specialist expertise in commercial construction, insurance, property damage, and professional negligence disputes. Sir has been involved in mediation disputes since 1996 when he took his first mediation in Singapore. Sir has been involved in over 200 mediation and has done the mediation at both domestic as well as international level for almost 25 long years. As a mediator, Sir acts in a wide range of commercial sectors, including insurance, property damage, construction, and general commercial disputes. Sir has disputed commercial disputes valued at $10,000 to $100 million and have received glowing feedback and testimonials on the great performance and skills. Sir has used his background and experience as a successful QC and commercial practitioner. Sir has used all his skills to become user-friendly mediator. He combines various and varied kind of mediation, be it facilitative, evaluative, or translative. Sir is an advocate of early stage mediation. Sir also practices as a single and panel arbitrator in the commercial arbitration and has been a fellow of the Chartered Institute of Arbitrator since 1999. Since 2019, he has been a trustee of the Chartered Institute of Arbitrators.
Well, thank you very much for that kind introduction to Andrew Miller. As I mentioned, I've received an email from him to say that he's running late and he's caught in traffic in Dubai. So I wish we were all there, since I dare say it's both warmer than where I am and more interesting than where I am. So I know that he was going to speak to you on cross-border perspectives in mediation, and in particular in commercial mediation. And can I just pick up on the areas that he would necessarily have touched on, although he hasn't provided me with any specifics about what he was going to say. My own experience is of course in mediating in the Gulf, like him, and also in Singapore, Hong Kong, and the global impact of mediation, of course, is going to be felt much more readily now that we have the Singapore Convention in place. And but that apart, I think there are a number of areas that you have to be alive to in dealing with cross-border commercial mediation. The whole essence of work being cross-border is that there needs to be an understanding of 4 very separate and distinct areas which are of great importance in this consideration. And since almost all of us come to mediation in the shadow of the law, because commercial disputes arise out of, generally speaking, out of breaches of contract or breaches of property rights, intellectual property, or tortious claims. The first question, of course, is whose law? Because there will be a law which governs a contract. There will be a law which governs civil rights attaching to a particular state. And therefore, there will be a law which governs the relationship of the parties within the mediation. In fact, of course, if mediation operates under the supervision of the courts, then there will be a proper law attaching to the process anyway. So it's as well to start our particular journey by establishing whose law is going to govern the mediation process, as well as the substantive law of the contract. That leads us, of course, to the next question, because if you're dealing in cross-border work, there are, but by and large, there are 3 systems of law which you have to have regard to. Is the framework of law under which you're operating going to be civil law? Is it a common law jurisdiction? Or could it stretch to a religious law jurisdiction? And this depends on the nature of the commercial dispute and where the dispute is going to be determined on a jurisdictional basis. Now, for those of you who work in civil law jurisdictions, the essence of the law is that it is codified in one place. And the great thing about a codified system of law is its accessibility. But the downside of a codified system is its inflexibility, because the law does not change terribly easily, and judges and arbitrators do not have the necessary freedom to deliver what might be an objective sense of justice. Common law jurisdictions, they have the great benefit of flexibility, and normally when you're using precedent as a systemic approach to determinism by a judge, judges will have sufficient flexibility within the precedents and court-based rules that they're looking at to exercise a discretion in favor of delivering practical justice to the parties. But as against that, common law systems are notoriously inaccessible, because the only people who know what the law is are the lawyers themselves, and therefore not everybody can have an understanding of law. Religious systems have probably greater influence than you would imagine, but on a global basis. But of course, it's entirely possible that the contracts can be governed wholly by a religious system of law. And then, of course, what you're looking at is the relationship between religious law and secular law as it's applied, and may be applied in supervising the mediation. The next question, of course, is whose process? If you're undertaking cross-border work and you've established which law is going to be applicable, the next question is, which kind of mediation process are you going to submit to? I've already mentioned in my other session that mediation processes are not fixed and can be used to accommodate the wishes of the clients. Now, in commercial mediation practice, it will be the lawyers who will be negotiating with the mediator what process is going to take place. Now, that's not simply a question of whether it's going to be one national's process or another. It will extend to the nature and role of the mediator. So the mediator may very well be asked to undertake a hybrid process in which, even though the parties start off by engaging in facilitated negotiations, because of the need for certainty and because of the need for finality, they move into an evaluative approach where either the mediator at the end is asked to make a non-binding recommendation or is asked to move into an arbitral mode and make the decision for the parties, which they then accept will be binding. So process negotiation takes a significant part in pre-mediation discussions, because you need to know exactly what it is you want from the mediator and how the mediator is going to run the process and what the outcome is going to be in terms of process. So that therefore leads you on to the next question, which is mediator selection. Now, mediator selection then becomes extremely important in cross-border work, because there are a number of skills that a mediator has got to have, which you may share as a lawyer, but which are essential to the mediation process. And these are certainly concerned with both cultural and linguistic understanding of the parties' needs across the national divide, or the cross-border divide. And first of all, is it possible to have a bilingual mediator in respect of both parties' languages, primary languages? Or do you have to have a mediator who, for safety's sake, has a contemporaneous interpreter working with him or her? That leads to the question of the proficiency of the interpreter. And that can be a serious matter. I work, by way of example, I work in commercial mediation in Turkey quite frequently. And although I can only speak English, I have to try and test in some way the interpreters that I use. Because what concerns me immensely is the fact that in English in particular, but I have no doubt in many other languages, people speak in idiom and people speak in phrases which are everyday phrases, but which a non-native speaker might find difficulty with because they would take the words as having a literal meaning when they don't have a literal meaning. So generally speaking, I test the interpreters, and this is quite a good way of doing it. You say to the interpreter that you are going to start by giving a joke. And you say the joke and say, is it possible to translate that? And the interpreter will say, yes, we can interpret that. We can interpret that. It's not a problem. And then you wait, because invariably the interpreter will then say, but why is it funny? And of course, that tells me that the interpreter understands the words, but cannot convey the meaning. And therefore, it's absolutely essential that if you're selecting a mediator that's going to have to work through an interpreter, that you also select the interpreter or have confidence in the interpreter as well. If you're going to engage a mediator on the basis that the shared language is English, people's non-native standard of English it varies, and I have to accept that it varies. And people who are primary English speakers, they have an advantage. And I suppose I'm ashamed to say it, but in my experience of even competition work, student mediation competition work around the world, suggests that for non-native English speakers, they are acting under a disadvantage. And it's often the case that when you look at competitions, I think subconsciously the judges are attributing marks to proficiency in English without actually saying so. I may be wrong about that, and of course I'm sure I'm wrong about it so far as this competition is concerned. But I do think proficiency in English suddenly becomes quite important. The mediator has to ensure that there is a complete linguistic understanding as between the parties. One of the fundamental tasks of the mediator in commercial mediation on a cross-border basis is to make sure that the parameters for the dispute are set, that each party understands what the issues are, and that each party understands what the other side is saying about those issues. There is no point in trying to get the parties to come to an agreement if there is no true meeting of minds, because there is no true understanding of what has been said, and therefore what the settlement actually means in practice. And of course, the mediator has got to be appointed on the basis that there is a complete cultural understanding of matters which are important to both sides on a cultural level. Now, when I say cultural, I suppose I mean socio-cultural. I'll give you an example. I've been mediating in Dubai last week and the week before, and you have to have a sense of what I call the patrilineal structure of a family, where parties are negotiating within the mediation, But it then becomes apparent that the true decision maker is not present. The true decision maker is a senior member of a family who's never come to the mediation and has never been affected by the arguments that are being put in front of the mediator. Nor is the decision maker ever heard what the mediator has to say about certain matters. And that gives rise to an authority question. The parties may come to the mediation and say they have authority to conclude a negotiated agreement. But you have to wonder whether that's true, and that in fact, there's going to be a ratification process afterwards. Now, this is part of a broader cultural identity that the mediator has to be aware of. And in many senses, this is not a legal issue, it's an anthropological issue. You need to understand that in the early days of modern mediation, the 1950s to 1960s, the proponents of modern forms of mediation were not lawyers, they were anthropologists. And what they were looking for were culturally diverse, almost ancient ways of decision-making for the purpose of creating a modern, a fairly diverse, but certainly a modern approach to challenging the orthodoxy of legal determinism by judges, and also challenging the orthodoxy by which lawyers are trained. When you move into the idea that you have to have cultural understanding even before the mediation can start, I think that's perfectly true. I think, for example, it's important for negotiators to read up about the cultural matters of cultural importance to the other side, having regard to where they come from, and matters of cultural importance may have a resonance when you arrive and turn up for your mediation. So, for example, if you're mediating in Japan, you need to allow extra time, because at the beginning of what you think is a mediation session, the Japanese will not negotiate with you until they are comfortable in knowing who you are, in knowing about your family, in taking you out for a meal or a drink or for a round of golf. And for them, that's a natural part of understanding your cultural sensibility before negotiating. But you don't see that as part of the mediation at all. You see that as a delay. So there's a good example of cultural understanding. American mediators will be extremely keen to just get on to the negotiation phase. They're not really interested in the exploration phase or the introductory phase of mediations. And you need to be aware of that before you start engaging with them. And there are anthropological reasons for the way in which different cultures approach negotiation differently. And these are all matters that I think you need to learn up about, read about, once you know that you're going to be engaged in a cross-border mediation involving a culture which is different from your own. So I don't know where we are in terms of your timetable. I haven't heard from Mr. Miller again. I don't know whether, in fact, it would be useful for participants to ask questions at this point.
All the participants, if you have any question, please raise your hand. We'll unmute you. So I believe there are no further queries today. The
Okay.
participants have understood the concept that you delivered today. Yes, sir.
That's good. Can I mention one other matter before I conclude?
Yes, sir, sure. Sir.
I've talked very specifically about understanding whose law, whose process, mediator selection, and cultural and linguistic understanding. Of course, in addition to that, you have to overlay the subject matter of the dispute. In international commercial mediation, it's quite likely that the parties will be engaged on a dispute involving matters where the industry operates internationally. And it's quite likely that there will be standard form contracting, that there will be some level of standard form standards attaching to the way an industry operates, whether you're talking about energy, oil and gas, infrastructure projects, PPP contracting, or ITC. You may be talking about funding by the World Bank, or you may be talking about operating in a sector which is covered by multilateral agreements. And one of the ways of approaching a cross-border mediation is to identify industry standard frameworks that you could make use of, so that you're not operating on an entirely blank canvas. If you have industry rules, and then if you have legal rules, and if you have process rules for the mediation, then they are there not as constraints or obstacles, but they are there to afford you with guidance, to enable the mediation to operate in a way which gives you the confidence to know that you're not operating in a vacuum, where your own decisions may be more questionable. You've got these various frameworks, and it's important that you make use of them and for your advantage, for the advantage of your client. But ultimately, it doesn't matter whether we're talking about hundreds of millions of dollars or whether we're talking about relatively small amounts. You're trying to identify interests between the parties that can be reconciled. Sometimes it's simply a matter of money. At other times, it's a matter of money plus money's worth items. If it's just a question of money, it may be applying time to money. So working out when payment is going to be made, over what period, and dealing with the default position. But invariably, there is one thing that mediation can do that a court cannot. And in the age of COVID, I think it's very valuable, and it's why lawyers should reach to mediation first. Mediation enables parties to renegotiate contracts. That's something a court simply cannot do. And if you think the solution to your problem isn't enforcing a contract, but of necessity renegotiating it, then get it away from the court system as fast as you can. I do hope that my few words have been of use to you. I wish you every success in the competition work that you are doing. And of course, I wish you every future success in working as mediation advocates, as well as working as lawyers. Thank you very much.
Thank you so much, sir. It was really such a good pleasure, and it was so fruitful hearing you. You delivered the knowledge on your topic, role of negotiators, and as well cooperated with disseminating the knowledge on cross-border perspective of mediation. Thank you so much, sir, for joining us today.
Great pleasure. You have the rest of your day.
Sorry, sir?
Thank you. Bye-bye.
Thank you, sir. Dear participants, we are now starting with the mock mediation session that we have scheduled today. We will take another 2 minutes. In 2 minutes, 3:15, we'll start with the mock mediation session, which will be done by the team of Lloyd Alternative Dispute Resolution Center. We have here with us our mediators, our mock mediators, Mr. Ranjit Panwar, Mr. Robin Singh. We have our clients, Ms. Shreya Singh and Ms. Simra Mohan, and our counsels, Mr. Devansh and Mr. Akshat Garg. The team is ready to give you a brief about the mediation session, which is going to be conducted from 25th to 27 March 2022. We'll start the mock mediation session in another 2 minutes, which is 3:15. Thank you for your cooperation. All the mock mediation team, kindly check your audios once, if you're able to unmute yourself.
Hello, am I audible?
Yes, you are.
I hope I'm audible to everyone.
Yes, you are.
Thank
Hello,
you.
am I audible?
Yes, you are.
Hello, good afternoon.
Am I audible?
Yes, both of you are audible. Ranjit, please confirm.
Hello.
Yes, you're audible. We are starting with the mock mediation session of today. I'll give the floor to the team, starting from the mediators. Thank you. All the best. Before that, one of the team member will give you a case brief, a summary of what the dispute is today on which the team is going to do the mock mediation. Spreet?
Thank you. The present dispute is between Edelweiss International Limited, which has a distribution business of digital hardware based in Thailand, and CompuCat Limited, which is a hardware manufacturing company based in Singapore. They both entered into an annual distribution agreement regarding their gaming console Ferrari. The dispute arose due to the breach of contract between the parties regarding the target sale and the distribution rights in the neighboring countries. Thank you.
Thank you. And now I pass the floor to the team.
Thank you so much.
Please
Good afternoon.
excuse me, can we just wait for 1 minute? Actually, the other party's client is joining in a minute.
Sure.
Thank you.
Good afternoon to both the parties present here. It's so good to see you both here. I am Ranjit Pawar, a certified mediator with 17 years of experience. Will be co-mediating this session with my co-mediator, Robin Singh. You may denote us by our first names. How would you like us to address you?
So, very good afternoon to everyone. My name is Henry Lee, the Chief Executive Officer of the company CompuCat Limited, and you can call me by my last name, Mr. Lee.
Good afternoon, everyone. I am Ross, the legal representative of CompuCat Limited. You can address me by my first name, Ross. Thank you.
Hello, everyone. My name is Cyril D'Souza. I'm the Managing Director of Edelweiss International Limited. Feel free to address me by my first name, Cyril.
Thank you so much, both the parties. First of all,
good afternoon. Good afternoon, everyone. I'm the legal counsel for Edelweiss International Limited. You can call me by my first name, Monica.
Thank you so much, both the parties. First of all, I would like to welcome you in today's mediation session, and also would like to thank you for choosing this mediation process, and especially to the counsels for guiding the clients to this mediation session. Let me begin by stating that we are not acquainted with any of the parties involved in this dispute. Mediation is a voluntary and a confidential process. The purpose of our meeting is to help you work out an understanding that is acceptable to both of you to resolve the situation that has been developing for you. We believe that both the parties have signed a mediation agreement, which basically states that you are here of your own accord. I would like to ask both the parties, are you all here voluntarily?
Yes, mediators, we are here voluntarily.
Yes, Mr. Mediator, we are here voluntarily.
Thank you so much. Also, we would like to know that, do you have the authority to settle and sign if an agreement is reached?
Yes, Mr. Mediator, we do have the authority, but the final decision shall be taken by my client. Thank you.
Yes, Edelweiss also have the authority, and Swill will take the final decisions. Yes.
Thank you so much, both the parties. I welcome you again. And now I would like to hand over this forum to my co-mediator, Robin Singh.
Okay, so hello everyone and good afternoon to everyone. I'm Robin Singh, today's co-mediator, and I'm a certified mediator and I have a 10 years experience in this field. So now, first, due to this pandemic, we are forced to conduct this mediation process through online session. But if you feel like you have any internet problems, I don't want any communication barriers between us, so please let us know. So now I will introduce you with mediation. Mediation is a very dynamic, flexible, and a voluntary process in which a neutral third party assists the negotiation between the parties at conflict and come up with a mutually beneficial solution. Our role as mediators will be to facilitate a constructive discussion between the parties. We will be helping you to come to an agreement. We will at no point be providing any advice or any solutions to any of the parties. We will make sure that we are being neutral and we are fair. If you feel like we are not being neutral and being fair to each of the parties, you may let us know, and we will surely readdress the situation. Now, let me brief you about the procedure. Firstly, we are all here together in what is called the joint session. We will begin by hearing each of you to explain to us as mediators exactly how you view things. What's your perspective on the things? We will try our best to understand your side of the picture. After that, we will move forward by identifying and agreeing on what the basic issues of this agreement are. After this, we will examine exactly what you want from each other and what some possible solutions might be. After this, if either of the parties would like to speak to us privately, they can call for a caucus session. A caucus is a private meeting. If any of the parties would call for it, if you will go to caucus, we will do so immediately. When we are caucusing, we will be bringing a message from one party to the other, and we will ask if there is anything you wish us to hold in confidence, and we will hold it in confidence. Also, be aware that negotiating is a give and take process, and I request you to be more flexible and think positively. I personally like to think positively and also invite you to do so. So hopefully we will reach an agreement which is suitable for both the parties. Now, Ranjit Pawar will take over from here.
Thank you so much, Mr. Robin. We would like you to understand what our role is. Our goal is to help you figure out your own solution to your problems. You are the ones who will be leaving with your solution from here on. So we want you to be the ones who decide what the solution would be. We won't be telling you what to do or trying to judge you who is right or wrong. We are much more interested in helping you to reach a solution for the future, not to judge you what happened in the past. Mainly, we are focused in helping you talk about the solution that both of you can live with. We want you to reassure that anything you say in this session would be confidential. We'll be taking notes from time to time so that we can remember things. But when we finish, we will destroy our notes. Last of all, we would like you to discuss the ground rules a bit. We ask each of you to agree not to interrupt when the other person is speaking. If you wish to respond to any of the things, please note it down. We would also like you to agree to avoid the use of any abusive language, name calling, etc. These rules are especially important in our next part of discussions. The requesting party, do you agree with the rules?
Yes, mediators, thank you for the rules, and I do agree with all the rules.
The responding party?
Yes, Mr. Media, we do hereby agree with all the rules set forth.
Thank you so much.
Okay, thank you to both the parties for agreeing on the terms. So without spending much time, I would like both the parties to begin with the hearing, their opening statement. So I would request either of the parties to start with their opening statement.
So thank you, mediator. So first of all, obviously, I would like to thank the mediators, Mr. Robin and Mr. Ranjit, for being with us here today. I would also like to extend my thanks to the responding party, Mr. Cyril D'Souza, along with his lawyer, Ms. Monica, for agreeing to sit and discuss certain pertinent issues with us here today. And to thank mediators also, because I think they have done a great job in explaining the process really successfully and really comprehensively at the same time. This process undoubtedly has initiated a deep level of confidence in me that this method of dispute resolution will definitely lead to a lot of constructive dialogue and hopefully a streamlined resolution too for any and all the contentions raised here. That being said, I would just begin by giving a brief introduction about my company, CompuCalc. As you all know and aware of the fact that CompuCalc is a hardware manufacturing company based in Singapore, which works for the manufacturing of computer and gaming hardware devices. With thorough hard work and time invested, my company came up with a new console named Ferrari, which became a bestseller. My company has also won accolades for the same, and many big profiles of the industry have appreciated the hard work of my company. Edelweiss International Limited is one of them. So it's been a pleasure getting to know Edelweiss these years and seeing their immense contribution to how sales are done at Honest. Edelweiss and I have been working together in the past endeavors too, and we share a really good commercial relationship. We started working with Edelweiss International Limited with utmost trust, confidence, and accountability, and I hope that is the same from their end as well. When my company came up with Ferrari, I was delighted to enter into an annual distribution agreement for 12,000 consoles, gaming consoles to be sold each year by Edelweiss. Though at first I couldn't even think of any such circumstances which would lead to us to sit here in a room discussing things with Edelweiss. But Edelweiss being one of the oldest distributors in my region, my company will try their level best to settle the dispute through mediation and to work further in the future. So the concerning matter which brought my company to this process of mediation is with regards to the demands of reimbursement which Edelweiss faced by delay in payments and bad debts by their customer, about what went wrong with the contractual obligations. Moving on, we would also like to have some words on the fulfillment of the annual agreement from October 2019 to October 2020. Concerning that, Edelweiss is able to sell only 7,000 Ferrari 2.2 consoles units. Now, Edelweiss must sell 5,000 more in the remaining tenure, and this is likely because the non-fulfillment will lead to the termination of the contract, which will damage the financial prospects of Edelweiss the most. Over and above, asking the company, to take back those 500 consoles of Ferrari is deeply surprising and regretful that we are sitting here today to address you. And lastly, as this being said, Mr. Mediators, both the mediators could note this, that our number one priority here today is to understand the nitty-gritty of the dispute, as I believe that understanding our past relationship and what went wrong is important. So we can build a future relationship, a coming relationship in a more structured and better sense. And definitely we are here in the mediation process, so we want to reach a conclusion where both the parties settle amicably. And I hope that the conclusion which we are going to agree upon isn't based on half minds or mistrust, but it will definitely be the one which will be carried forward with mutual trust, confidence, and we will be able to bring out the best for us, for our customers, and for our clients. Thank you so much.
Thank you, Henry. I would first of all like to thank the mediators for willing to mediate and facilitate this session. I would also like to thank them for explaining the rules and procedures of this process. I would further thank the other party for choosing mediation as a dispute resolution solution and mechanism process. I would like to clarify the intent of CompuCalt also here, that we want to reach to amicable solution through which we can continue our business relationship with Edelweiss, which we have created in the past. My role here will be advisory, and I will be legally assisting and supporting CompuCalt Limited. Thank you.
Thank you. And now I would request the responding party to please start their presentation.
At the outset, I would like to thank both our mediators, Mr. Ranjit and Mr. Robin, for facilitating this mediation and for reassuring us about the confidentiality of this session and its entire procedure. I must say it has been really helpful in calming my mind and gave me a sense as to what I can expect from this mediation. I would also take this opportunity to thank you, Mr. Lee and Mr. Ross, for calling this mediation and for initiating this session, as I do believe this is a way through which we can settle our differences amiably and reach a middle ground through which both of us can walk away with contentment in our hearts. At the same time, it is equally comforting to us that yes, CompuCalc Limited is equally committed in restoring its relationship with us. That being said, I would just like to begin with a brief introduction of Edelweiss International Limited. Edelweiss is a digital hardware distribution company based in Thailand, which is my home nation. My grandfather started this company with utmost sacrifices, and together with the collective effort of teamwork, of diligence, of hard work, and of honesty, we have established a robust distribution mechanism in almost all gaming sectors and in the distribution of digital hardware systems in almost all our neighboring companies, which have been running since 1990s. I must say that Edelweiss really values its business relationship with all our neighboring companies, as this is something which my grandfather taught me. He really cherished his relations with all our neighbors and he valued them. He really owed a big part of his success to them. I believe this is something that Edelweiss really prides itself upon. Edelweiss entered into an agreement with CompuCalc Limited regarding the distribution rights in our neighboring companies with much enthusiasm and trust, as we really believe that your new game Ferrari is a game changer in the gaming sector. We have been very successful in the distribution of Ferrari in the first annual year as per the agreement, and our sales exceeded by 2,000 consoles. We were equally excited about the launch of their new version of this game, Ferrari 2.0, and ordered it in huge numbers. Personally speaking, I was very excited about the product. My kids loved it, and we spent hours playing with it. The world, as you and I, and we all know, came to a halt after the COVID-19 pandemic. Our distribution network was totally disrupted, and we had to halt our services. Due to the same, Edelweiss incurred huge losses. But the situation is being aggravated by the leftover outstanding stocks of the old version of Ferrari. I would also like to state that yes, we do realize that CompuCalc Limited's operations have also been affected by the pandemic, and it was equally unforeseen by both the parties. In my able sense, I also realize that the immediate discord between the parties has also occurred due to the lack of communication between us regarding the distribution rights in Singapore and Indonesia. I must say that we are not here to point allegatory fingers at each other. Rather, we are aimed to settle at a consensus, and from where both of us can walk away with contentment and pave our way for healthy future relations. Further, I'm not here to dwell in the legal nuances of this dispute, and I request my counsel, Monique, to explain our position and our intentions in a better way to you.
Thank you, Srill. First of all, Thank you, Ranjit and Robin, for briefing us about the process and uniqueness of mediation so well. From what I have already heard, both Edelweiss and CompuCalc share a real interest in preserving their business relationship. Although we may not physically sit together today, I hope these shared interests can serve as a common ground across this virtual table. I am here first and foremost to protect and to put forth the interest of Edelweiss, and my role today is merely advisory, and still will take all the major decisions on any offers put on the table. I realized that there are various claims arising out of the agreement. However, Henry, keeping these legal views at aside, Cyril is here because he wants to explore how you both can work together to overcome your differences without resorting to the costly and time-consuming process of litigation. We are quite clear that we want to resolve this dispute at this mediation table itself with the help of Ranjit and Robin. And in that vein, Henry, I also want to echo and acknowledge my satisfaction when hearing your own statement that this was something you two shared, as well as Ross. So to broadly highlight our objective today in this negotiating, we'd like to discuss the losses incurred by Edelweiss and the reimbursement for the same. We would also be interested in discussing the potential of a future relationship of both the parties together. To guide that conversation, it would be helpful for us to structure the conversation today and set an agenda. And Henry, we would be interested to hear how this fits with what you like to discuss today. Robin or Ranjit, would you please navigate us from here?
Thank you so much, both the parties, for clearly stating your interests and your side of the story, what the parties think. After carefully listening to the opening statements and understanding the interests, it comes out that the agendas for our discussions would be one regarding reimbursement, and the second, breach of contract with respect to the distribution rights. If my co-mediator agrees with these points, we may proceed further.
Yes, I would just like to ask if the parties agrees with the same.
Yes, mediator, CompuCalc agreed with the same, the points that have been put forward by the mediators.
Okay, so I will just once repeat all this. Breach of agreement of exclusive distribution rights and fulfillment of annual agreement. And the second one is the reimbursement of losses incurred by Edelweiss.
Yes,
All
Mr.
right? Okay, so I would like to proceed with this. And the parties, could go to the joint session and negotiate the offers.
Thank you, Mr. Mediator. As I mentioned earlier, Edelweiss International Limited is not here to point allegatory fingers at each other or to blame anyone here. Rather, we are here to understand the position of CompuCalc Limited and to understand that the pandemic has affected them as well and they have incurred losses as well. However, I believe it must be realized that there has been a breach of contract on the part of CompuCalc Limited regarding the distribution rights in Singapore and Indonesia. As per the original agreement, we were to get the distribution rights in all our neighboring countries, including Singapore and Indonesia, but we were denied the same. Furthermore, the COVID-19 pandemic, as I explained earlier, totally shook our business and we sustained huge losses. Currently, Edelweiss is under a financial crunch, and it breaks my heart to say that this is due to bad debts and delay in payments by our customers. But the situation is also being aggravated by the outstanding stocks of Ferrari. And to relieve the financial situation, I feel Edelweiss is right in claiming compensation of $65,000 from CompuCalc Limited and asking them to take back the 500 consoles of Ferrari. I would love to hear what the other party has to say on this regard.
Thank you, Cyril. I do understand with all what that has happened with you, and I feel pity for the same. But I don't really think that my company would be really be able to reimburse the set amount as stated by you. However, as we are in the negotiation process and we share the same vision to settle the dispute, I do believe that no doubt we'll be able to come up with the best possible solution for both of us. Now, coming up to the claims that you have put forward, including to take back the 500 old Ferrari consoles or the reimbursement, I would like to bring into your notice that we cannot do the same because, as clearly mentioned in the agreement, on which my counsel would be focusing more. We are for sure not here to enter into legal nuances or deal with the contractual obligations. However, to strengthen my position, I would like my counsel Ross to add on more. Thank you.
Thank you, Henry. As my client already stated that Edelweiss did suffer a loss of $65,000, but I would state the terms and conditions of the agreement here, which clearly states that neither party was liable for loss incurred by the other party under any conditions whatsoever. So I don't think CompuCal need to reimburse the loss of Edelweiss they suffered. And regarding the exclusive rights of distribution, I would like to point out that during that 2018 agreement, we insisted to sell gaming consoles in Indonesia and Singapore along with Edelweiss, which Edelweiss did not raise any query till date until they are under losses due to the pandemic. Also, I would like to draw the attention of this panel towards a very important discussion, which is regarding annual target of 1,200 sales. Edelweiss needs to fulfill that target. We will insist them to fulfill this target because this will not only be beneficial for us, but will also help them to reduce their losses. Also, they cannot ask us to take back 500 units of old Ferrari consoles because according to our terms and conditions, once a product is sold, it cannot be returned until it is defective or we voluntarily want to take it back. So there is no point in that. Thank you.
Thank you, Ross. I just want to remind all of us that we must not forget that we are in a mediation session. And prior to that, Cyril and Henry are here willingly to settle their differences. Henry, as we are discussing the agreement, I think it was you along with Cyril to agree on the terms and conditions of your agreement, according to which under clause 2, you were to provide exclusive distribution rights to Edelweiss in Singapore and Indonesia, which they clearly didn't receive. This not only reduced their anticipated profits, but also limited their area of distribution. Adding to which the unsold stock of the old version of Ferrari, followed by the unfortunate event of COVID-19 pandemic, acted like a fuel to this huge fire of losses. However, passing through these difficult times, Edelweiss has successfully distributed consoles in huge numbers. The particular clause of force majeure allows the partial fulfillment of the total requirement of 12,000 units admissible in that particular term, which Edelweiss has clearly performed. Ross, I believe that while inserting this particular clause in the agreement, your intent would be same as of ours to provide some relief in the unfavorable times. It is in the common interest of both the parties to retain their business relationship, and in order to achieve that, Edelweiss requires some important aspects to be considered, starting with providing exclusive rights in Singapore and Indonesia.
Agreeing to what my counsel just stated, I would just like to add on that yes, to explain my position in a better way, that yes, we agreed for the annual target sales of 12,000 consoles of Ferrari and its successive versions. Our sales were going exceedingly well before the pandemic, but our numbers dropped significantly as the transportation facilities in my nation was banned to curb the spread of the virus. It was impossible for us to achieve the target of 12,000 consoles. We believe that that Edelweiss is correct in considering COVID-19 pandemic as a force majeure event. And as for this, we agree to the partial fulfillment of the target. And I must tell you that the previous year, we sold 7,000 consoles, which is exceeding the partial fulfillment criteria already.
Mr. Cyril and Monique, I heard about your experience and with what you have struggled with. And I really understand and can actually sympathize with your situation right now, like you have just mentioned about COVID-19, due to which you have suffered a huge loss and you are still recovering and would be recovering. Carry on your business is no doubt commendable and appreciable from my company. But I cannot give your company the exclusive rights of Singadur because Singadur is my hometown and I'm deeply connected to it to the core of me. I have grown up here. My business has grown up here. My business has started from this place, from Singadur. And over 60% of my success factors of my business, are connected to this place, which I have. And also with related that, apart from 60% success factors, I have other stable business plans too from here. And also, as you have mentioned about the partial fulfillment of the agreement, which CampuCalc really appreciate, but I'll definitely go by the fact that by June 2020, the distribution operations resumed, and like you could have fulfilled the agreement, could have fulfilled the demands that were mentioned in the agreement in the same, but your company decided not to order any more consoles for the ongoing annual term, which directly means that you did not intend to fulfill the agreement even after all the facilities being resumed.
Mr. Lee, I understand where you're coming from. I understand and I acknowledge your concerns. As the managing director of Edelweiss, I believe I have a higher sense of responsibility towards my employees, towards my companies, and must protect the honesty with which they work. I'm sure that this resonates with you, Mr. Lee, as well, and you must be understanding what I'm trying to convey here. Our operations primarily include sending our goods to the retailers who further sell the goods to the customers. Transportation is one of our key elements, and without it, we cannot sustain our business. The pandemic made it impossible for us to continue our services, but even in those trying times, we still sustained sales of 7,000 consoles, which is a good number. Further, we ordered Ferrari 2.0 in huge numbers as we were to get the distribution rights in Singapore and Indonesia as well. However, we were denied those rights, and Mr. Lee, we incurred losses there as well.
Mr. Cyril, I think like we are being repetitive in our points in our statements, and right now we are going nowhere to find a best possible solution for us, for both the parties. So I would like to have a private caucus session with the mediators.
Okay, so if both the parties are agreeing on this, that we would go for caucus, maybe requesting party stays here and the responding party please move to the breakout rooms and we will go for a caucus session.
Sure, it will be done in a while.
Thank you, both the council and the.
I think there's no breakout room. The supervisor, yes.
Yes, it's done now.
Thank you so much. So I would just requesting party to please.
My legal counsel would definitely start first.
Thank you, Henry. Thank you, mediators. I would like to bring this into notice of the mediators that as per the distribution agreement, the exclusive rights were to be given to Edelweiss, which we did not. We failed to do that. And I would like this information to be confidential with you, and I don't want it to be shared with the other party. Thank you. Further, my clients will take on the session.
Thank you so much, Ross, and thank you so much to both the mediators for having this private session, for having the caucus. So I would just begin by acknowledging the fact that no doubt COVID-19 was an uninvited and surprising event that is force majeure, which is being applied to us. And with that, we have also, faced the loss, and it has definitely affected our business industry as well. So I would like to offer Edelweiss International Limited 5,000 consoles, and with that, we'll be taking back from them 500 old Ferrari consoles, which they mentioned earlier, so that with this, like, the contract can also be fulfilled and renewed again. Because my company right now, like my company, without any half mind, want to, you know, do not create a relationship which is built on mistrust, and we want to continue our relationship with our commercial relationship with Edelweiss International Limited. Thank you, Mediator.
Okay, so Mr. Lee, what you are saying is, and your counsel is that according to the agreement, you were supposed to give them the exclusive rights, and you were not able to give them. And this is the information you want to keep us confidential.
Yes, Mediators. Keep this information
And-
confidential and propose. You can propose the offer which you have.
So we can
in front of you.
share the offer with the other party.
Yes, yes.
Okay.
Thank you so much.
Thank you. I would just request you to move to the breakout rooms and request the other party, the responding party, to please come to this session.
Okay, thank you.
Has the other party joined?
ये हमें क्यों इनवाइट कर रहे हैं? ये हमें इनवाइट कर रहे हैं.
The breakout room is being created for the other party. Please hold on. Yeah, it's done now.
So I would request the responding parties to please start.
Please switch on your cameras.
Yes, Mediators. So, in the light of
Just a second, Monique, if, before you proceed.
Yes.
Feel free to share anything you wish to. This is a caucus session, which is a confidential session. The information you share here would be between mediators and and between you, until unless you agrees to share any information with the other party. So feel free to share anything. You may proceed. Thank you.
Okay, thank you, sir. So, in the light of the prevailing circumstances, Edelweiss is aware that as per the terms of the agreement, neither we can force them to take back the 500 units, nor we can make them reimburse for the losses. But what we are aware of is that everything happens with trust and mutual cooperation. And I believe that they both will restore their relationship if they agree to grant the exclusive rights to Edelweiss. And for us, still would be comfortable in buying some of the latest consoles only if they accept to take back the 500 units of the old version. Sil, would you like to highlight your concern?
Yes. Mr. Mediator, currently the demand of Ferrari is significantly lower. At the moment, Edelweiss cannot afford to keep those 500 consoles of the old version of Ferrari with us. However, we come to this mediation table to settle our differences and to restore our business relationship so that we can continue having healthy future relations. Therefore, in light of this, we propose to order 3,700 consoles of Ferrari 2.0 in exchange if CompuCalc Limited accepts the 500 consoles of the old version of Ferrari. This is the most that we can afford at the moment.
Thank you so much, Cyril and Monique. What I conclude from your statements is that the responding party wants to place an order of 3,700 consoles and wants the Campucal to take back those 500 left out consoles, and in plus addition give the exclusive rights of Singadur and Pindonesia too. Is that right?
Yes, that's correct.
Thank you so much. Let's move to the joint session.
And
Yeah.
also there's one request. You may tell them about our proposal, but I request you to keep the rest confidential, please.
Sure, sure. Thank you so much. I welcome both the parties back to the joint session again. The caucus session was a confidential session that was held subsequently with both the parties. Abiding by the rules, we have held some information confidential, and as agreed by both the parties, we are disclosing some information. The Edelweiss, that is the responding party, wishes to place an order of 3,700 consoles if they get the exclusive distribution rights, and if the other party wishes to take back 500 consoles to them. And what the requesting party, that is Campucal, wishes to offer you is they wishes to offer you 5,000 consoles. If you place an order of 5,000 consoles, they'll take back those 500 left outs. Now it's upon you, both the parties, to take a final decision. Thank you.
Okay, the offer that Edelweiss International Limited has suggested. So with respect to that force measure being applied to us also, I don't really think CampuCal would be able to agree on 3,700, because the critical moment in the world and with the situation that is being evolving quickly, we are with utmost trust with our company, trying to recover the loss, and selling 3,700 Ferrari 2.0 with taking back 500 old Ferrari consoles is not suitable to our ground. 500 Ferrari 2.0 is the best that CampuCalc could do for Edelweiss International Limited.
Mr. Lee, we understand your position and we understand your concerns, and we also understand where you are coming from and that the pandemic has also affected you as well. We agree to your proposal to order 5,000 consoles of the Ferrari 2.0 as you take back the 500 consoles of the old Ferrari. Mr. Monk, would you like to add something, or would you like to explain our proposal in a better way?
Yes. However, adding to this, I would like to propose that if Edelweiss completes the target of 12,000 gaming consoles within the next 6 months, then in consideration to that, CompuCalc will provide us the distribution rights in Singadur and Indonesia for the next annual year onwards. Henry, this comes from us as we understand that Singadur is your home nation and you have a strong hold network over there. We will be glad to hear your views on it.
So agreeing and acknowledging the time period that has mentioned by Mr. Monik is acceptable to us, and we'll be giving you 5,000 consoles and taking back those 500 old Ferrari consoles. And we will definitely give you the distribution rights of Singadur and Indonesia if you achieve the target of 500 consoles in 6 months. I am happy that you respect and understand my part related to Singadur and everything. And alongside, I would also like to propose that as we are giving you the exclusive rights, then we will renew the set target of agreement from 12,000 consoles to 14,000 consoles annually with the set terms and conditions. And I'll just conclude with a note that we will now work in future with same trust and confidence with which we started, and it would be an honor for CampuCal to work with Edelweiss and continue our relationship in the near future and to expand our business with them. Thank you so much.
Mr. Lee, it is heartening to see both the parties reaching at a consensus, and we would be very happy in achieving newer heights and greater targets every year, keeping in mind that yes, we will get the distribution rights in Singapore and Indonesia. I will quickly take this moment to thank both our mediators for facilitating this session so successfully. I think, yes, we made a significant headway in understanding each of our positions successfully and coming to a conclusion from where both of us are walking with contentment in our hearts amiably. This has certainly paved way for our healthy future relations.
Yes, and I also want to take this opportunity to thank our both the excellent mediators, Ranjit and Robin, that we truly achieved the true meaning of mediation session, that we reached to a consensus agreement and the differences between them are resolved. I, along with Ross, we will look into the legalities of the new agreements and new terms and conditions. And thank you all.
Sure, Monique. We will see you soon. And I would like to also congratulate everyone and thank mediators and the other party for this session. Thank you, everyone.
Okay, so I would just be taking a little bit more time and restating the terms of settlement. So Edelweiss here will buy 5,000 consoles from Campo Calp and will return the 500 old Ferrari consoles to Campo Calp. All right. And the second is that there is a new annual agreement of selling 14,000 consoles and getting the Edelweiss will get the exclusive distribution rights in Indonesia and Singapore. Okay. So the agreement will be circulated to both the parties by tonight and both the parties could sign it. Now, I would like to thank you both the parties for being so understanding and also thinking so positively and fairly. Thank you. Now this mediation process is concluded. Thank you to all the parties present over here.
Thank you, mediators.
Thank you.
Thank you. Thank you, everyone.
Thank you both the parties. Thank you so much.
Thank you, everyone.
Well, thank you so much, Team Lloyd Alternative Dispute Resolution Center, for displaying this mock mediation session in a very fruitful way. I congratulate to the whole team for displaying this mock mediation session, and I appreciate your efforts made for today. Now we are moving towards the last phase of this workshop, which is a briefing about this competition and a Q&A session. I'll take 1 minute and I'll start with that. I request my teammate to please share the slides. Yes. So starting with a thank you note to all the participants who have participated with such a good patience since morning today with us. We had Mr. Anil Xavier, President IIAM and Chairman of AppCam today with us, who spoke on the topic of mediation overview of practice and procedure. We had Ms. Iram Majid, who spoke on the topic of role of mediators and the mediation plan. We had Mr. Andrew Goodman on the topic of role of negotiators, and who cooperated with us to continue and fill the gap of absence of Mr. Andrew Miller on the topic cross-border perspective of mediation. I would take 5 to 10 minutes to brief you about this competition of S.K. MISRA Memorial International Mediation and Negotiation Competition, 3rd edition. Firstly, I'll start with the timeline of the event. We have so far reached in the workshop stage, which is going on and which is going to be concluded today, that is 5th March 2022. Our next and upcoming stage is of the release of subsidiary rules. The subsidiary rules shall contain the other rules which has not been mentioned in the brochure so far, which might include the rules for the dry run, which might include the rules for the whole procedure. I would say every minute details of this competition would be there in the subsidiary rules. We have a dry run test scheduled on 21st March 2022, where the participants will be taken through a technical test with all their devices, either be laptops or the mobile through which they will be joining. We will be going on through a technical test with all the teams, how they need to rename themselves, how they need to join, and everything will be checked on that particular day, which is 21st March 2022. On 22nd March 2022, we will be releasing the team matches, which would reveal which team code is requesting party and which team code is responding party. The teams may prepare accordingly. For now, it is still confidential about the roles or the sites of the parties. Now, about the confidential information to be released. This time, we are releasing the confidential information one day before the event, one day before the rounds. Say, suppose we have the preliminary rounds on 5th March scheduled. The confidentials for the preliminary round shall be released on 24th March 2022. Similarly, for the octa final rounds, it will be released on 25th March night when the results will be declared after the declaration of result, which will be 9 p.m. Once the results will be declared, the parties will be shared the confidential information for the octa final rounds. Similarly, once the octa final rounds is completed, we'll share the confidential information of the semi-final round, of the quarter-final rounds, and then again in the same day, the teams qualifying for the semi-final rounds will be shared the confidential information. The rounds will be held 25th March, preliminary rounds, 26th March, octa-final and quarter-final rounds, on 27th March, semi-final and the final rounds, and the valedictory ceremony will be held on 27th March itself, which will start from 6 p.m. onwards. The whole event itinerary will be shared to you in the coming week, which will detail about the complete timeline of the event, whether it be the preliminary rounds, whether it be the octa-final rounds or the quarter-final rounds. For the very first time SK MISRA Memorial International Mediation and Negotiation Competition has introduced the green rounds for all the participating teams, which is based on the UN Sustainable Development Goals. The green rounds here, which we refer is the preliminary rounds. The problems of the preliminary rounds has been drafted on the environmental related issues. I believe you all might have received the problem and you are preparing the mediation plan on the same. The mediation plan is to be submitted by the 18th of March. Now, this round shall be a booster for all the budding lawyers to, pursue their career in an environment-friendly perspective. All the participants qualifying for the octa final rounds shall be eligible to compete further for the Trust Legal Climate Law Student of the Year awards. Now, what's the Trust Legal Climate Law Student of the Year award? This time, and I believe that this award shall be carried on in the next editions of this competition as well, where a student actively participating in the environment-related activities shall be evaluated and shall be judged as a Trust Legal Climate Law Student of the Year awards. Firstly, the qualifying criteria for this award is that all the octa rounds finalists shall be considered eligible for this competition. Means all the participants who will be qualifying from the preliminary rounds to the octa final rounds shall be considered eligible for this award. Once they qualify, they will further compete with the SK MISRA Memorial rounds, that is the quarterfinals, semi-finals, and final rounds. After completion of SKM 3.0, which will be on 27th March 2022, we will be circulating a Google form with a consent to proceed further with the other criteria of this prestigious award. Once you fill the consent form, there will be a three stages process to become the Trust Legal Climate Law Student of the Year award, which includes, firstly, a written submission on any of the green topics which will be allotted to you soon. Then a small video submission, which will incorporate a creative ideas to grow green. Third, a delegate role play, where you will be allotted or you will be assigned a particular country of which you will be allotted a delegate, and you need to think a change or a particular idea which can bring change to the problems, to the environment related problems of that specific country. Evaluation shall be cumulative of all the 3 rounds. You won't be judged on a single round. All the scoring of all the 3 rounds will be cumulated and you will be judged accordingly.
Complete details of this award or the qualification for this award shall be released in the subsidiary rules itself, or if not in the subsidiary rules, we'll release it separately on 15th March 2022. Now, coming to again back to the 25th to 27th March rounds, how are we going to proceed? We have in total this time 56 number of teams. We have locked the number of teams to 56 this time, and we have divided them into Group A and Group B. Group A consists of 28 teams from different universities, and Group B consists of different university teams. Now, every group shall be competing differently from the other group. Group A, where we have 28 teams. From there only, the qualifying students for the octa-final rounds. 16 teams will be qualifying for the octa-final rounds from Group A, and 16 teams will be qualifying from the Group B to the octa-final rounds. Now, after combining the octa-final rounds result, total number of 8 teams will be qualifying for the quarter-final, then 4 for the semi-finals, and 2 for the final rounds. So we have divided a slot of Group A and Group B, 28 teams accordingly. I believe when we'll be releasing the team matches, we shall be releasing the Group A and Group B chart also, that which team is in Group A and which team is in Group B. That would specify, like your groups as well, every university's group. Some rules I would like to highlight today, which is to be noted by all the participants. The mediation plan is to be submitted by 18th of March. The request to all the participants, and we'll be releasing it in the subsidiary rules itself, that all the participants shall be submitting the mediation plan on a given format. When I say a given format, I mean to say that there should be your team code, your name, and then you will be uploading the mediation plan on the portal itself. The portal for which the ID password has been generated, there is an option to upload your mediation plan. There you will have to upload your mediation plan by renaming your document, that too in the Word format, not in the PDF format. Many participants last time just uploaded the document in a PDF format. We need the Word document of the mediation plan. Again, each day delay in submission of the mediation plan shall lead to negative marking. All the participants should rename themselves during the oral rounds with a given format, which we have already provided in the brochure itself. We'll again provide it in the subsidiary rules, and we'll again repeat the same in the dry run. However, it has been observed that there has been a people do not follow the particular the naming criteria which we assign to them, which leads to difficulty in scoring the teams. So it's a humble request to all the teams to please rename yourself accordingly. Also, we have received certain queries related to whether the mediators will be allowed to share the screen or not. Yes, this time we are allowing the mediators to share the screen, but only to the mediators, not to the client and counsel, and not to any of the negotiating parties. The score sheet for all the rounds will be circulated to all the teams, all the participating teams, but at least a minimum of 1 week after the completion of the competition. Please, we request you to, after the completion of this competition, which is 27th March, will take at least 1 week or 10 days to prepare your score sheet in a particular format, and then we'll circulate to you via the email that you have given to us. Again, which we have also stated in the brochure, all the final decisions of the organizing committee in the organization, execution, competition, and administration of the competition is final and not subject to any appeal. The awards division, I believe we have also submitted this in the brochure which we have released. It's the best negotiating teams. We have hereby highlighted that which category of award is for which people, like which category of award is for mediator or which category of award is for client and counsel, because we received certain queries with regard to this. So here is the list of that. Best negotiating team shall go to the client and counsel both. Runner-up, again same. Best mediator to the mediator. Runner-up mediator to the mediator. The best mediation plan prize will go to all the three members, mediator, client, and counsel. Best opening statement for the mediator to the mediator itself. Best opening statement to the negotiator, client, and counsel. Now, the best teamwork between the client and counsel will go to both client and counsel and not to the mediator. Best relationship building with the other team, again to the client and counsel. Best creative solution, client and counsel, because they come up with a particular partner. Acknowledgement of cultural differences. Here, client and counsel will again be appreciated because we have international teams along with us. Best mediation advocacy is for the counsels separately. and the best performance for the first time participating team. We acknowledge and we appreciate the effort of every participating team which are with us for the very first time. The evaluation for all these participating team for the very first time will be done separately, and they will be rewarded with this specific category of awards. So now I think this is the last slide which we have is about the timings of the mediation session. This has also been incorporated in the brochure. The preliminary rounds, octa-final and the quarter-final rounds will be 75 minutes each, 1 hour 15 minutes, which will include a 15 minutes feedback timing. Semi-final rounds will be 1 hour 30 minutes, and the final rounds will be 1 hour 45 minutes. So this was a brief about the competition that we are conducting this time, the 3rd edition of SK MISRA Memorial International Mediation Negotiation Competition. Now I open the floor for the Q&A session for all the participants. Any of you who have any query with regard to the format of the competition, please raise your hand. I'll be there to answer this.
Hello, good evening. Thank you so much for briefing everything so swiftly. I wanted to ask if the mediators are also supposed to submit the mediation plan.
Yes, about that point, the submission of mediation plan is a collective effort of both client counsel and the mediators as well. The scoring of the mediation plan will be added to the scores of the client counsel and the mediators also. That's why we have scored that the best mediation plan will go to all the 3 people, like the client counsel and the mediators. Kritika, do you have any further question?
Yeah, thanks for unmuting. No, that's all. Thank you.
Thank you. Thank you so much. Any further question from any of the team member? Yes, Arya.
Am I audible?
Yes.
Yes, ma'am. Thank you for briefing. I just wanted to ask if the client and counsel are living in the same city, so can they, log in from the same device and the session be conducted together?
Yes, they can do that. However, they will rename according to that. Like you will first inform the OC about that. And when you start, like 15 minutes before, you need to log into the Zoom ID. So when you'll be logging in there, there will be a court in charge present over there. So you will inform them. They will inform you to rename accordingly.
Hello, good evening, ma'am.
Good evening.
Ma'am, when will be the general information for the further rounds will be released?
Like the mediation problem for the further rounds.
Yes, ma'am.
Hello.
Hello, ma'am. Am I audible?
Hello, Aishwarya. Can you hear me? Yes, so for the mediation problem for the other rounds, it is like we will be, after you submit the mediation plan for the preliminary rounds, which is on 18th of March, after the submission of the preliminary rounds mediation plan, then we'll be releasing the mediation problem for the other rounds, which is of octa and quarter. But for the semi-final and final rounds, we will release it specifically, I would say 2 to 3 days before the competition. Generally, we release the problems for semi-final and final rounds 1 day before the competition. It's an on-spot competition which goes for the semi-final and final rounds, but this time we are releasing it 2 to 3 days before the competition. So say suppose it would be 22nd or 23rd. Thank you. Any further queries? Thank you, everyone. I think we are done with today's session, including the Q&A session and the briefing of the competition. Thank you so much for joining and listening to us very peacefully since morning. I am looking forward to see you all on the competition date, which is 25th to 27th March. And before that, obviously on the dry run day. Thank you so much. Looking forward to see you in the competition. Bye-bye.